Steve, you have already set up for live streaming the volume on.
I agree.
Okay. Just to let everyone know that we are live streaming, the volume's on, so just so you're.
Thank you. Guys. What are you doing? Good.
Is that yours or mine?
Yeah,
that's
okay. She's like, yeah. All three of you are in trouble. But I had a tag hanging out my neck.
Oh, sorry.
Nobody
I
said
noticed
anything.
it too, but and if you know it, you just.
I thought that was what
you
was supposed to.
don't care. Sorry.
I apologize. I thought you did that on purpose. I was like, maybe he's rewearing it. I don't know.
Right.
I said it to my wife yesterday and she's like, you needed a mom there. I said, I did.
You did. I know. I'm sorry. I'm sorry. I did. I was like, I guess you had it. I figured you knew. So sorry.
Figured he's not as persnickety as I am.
I'm sorry. Sorry.
I'm not gonna cramp his style.
Yeah, because people do it. I see people all the time with their tag out. It's almost like Blair's pretty put together. He's probably he's gonna know. Sorry, Eric. I apologize. Mom fail.
Not just your job.
If you don't mind.
Nope, I don't mind.
Let me read this book.
Yeah.
To get that up as high as.
Can I help you think this?
I think it's trying to just put this up
On this.
on there. That was great. I think when it dropped, it popped out of the holes here. Actually,
It's on the hole, it's in the hole on this side.
down here.
Let me lift it and you can pull it.
Oh,
Get
the
it right.
screws popped out. Oh man, I have no idea.
Doesn't it go in the top little trough there with the padding? No, am I wrong?
No.
Right there?
It's only just in.
Oh, is there? Okay.
In here, you mean? It might. Let me see. I have no idea.
I think it would, right?
I think that's where it rolls up into.
Yeah.
It goes
okay.
here, and then it goes like this. The screws pop out.
So is
But
your,
as long as he hooks it, it should
Yeah.
stay up in time.
it is hooked now?
Is it hooked?
Well,
Okay, so we're just gonna have to
unless
leave
you put it against the.
it. We can leave it against here
Okay.
and leave it down. It might be too high. Yeah, maybe we'll roll it down a little bit.
It should go on this one.
Top and then, yeah.
Okay, and is
So
it,
then I'll undo the side.
Lord, is it gonna fit? Is that?
yeah. Okay, it's in.
All right, I think it's, but maybe
Doesn't look like on that side.
it looks.
Look,
I mean, as long as
it's halfway normal.
Yeah,
See if it
it's
holds up.
just,
It's kind of. No, it's kind of.
if I roll it.
Um,
We have,
what if we?
how about that? It's a little bit
Pretty
better.
good.
Is it okay the way it is?
Yeah,
Do you want it tilted or did you want it? You probably did, didn't you?
just so it stays up. Probably gonna tilt a little bit.
It's gonna fall.
Yeah.
There's something wrong. I mean,
It
we had it
popped out
before.
of the, yeah.
Is it high enough?
I think
I
it's
lowered
good.
it. I lowered it.
Yeah,
a
that's
little bit.
good. Okay, let me get. If you let go, will it stay? Okay,
I think it's staying.
yes.
Nobody fall.
Nobody breathe.
I
sure.
What if it was flush against the jury box with the visibility suffer?
We want
Oh,
it, we
let
want
me
it
see
pointed,
His
how-
projector's
yeah.
right there.
we want
Let
it
me get the
pointed
projector
towards the
going.
judge.
Yeah. Okay. Well, that looks pretty good. It might be a little distorted because of the
Yeah,
kind of
let me see
warping,
what I
but
can
it's not
do.
too bad.
Thank you, guys.
Do we know whether the issue with the Zoom link was figured out?
I don't know.
It wasn't a reason when you issue. No.
Huh. Okay. And I guess I kind of understood where he was coming from, like, it's you can dial in.
No, he was asking for the ID number. On the,
Oh, wait, okay, that's funny, because I looked and I didn't see
Yeah.
it either.
yeah,
Huh, okay, great.
and, there was also a way to call in.
Yeah. Okay.
Work?
We'll see. I'm just gonna.
Let's see what it looks like from the judges.
I'm gonna get the PowerPoint up. And then we can go from there. Okay, so let me get the PowerPoint up and see how it goes.
Yeah.
I feel like every time I come in, nothing helps.
Alright.
Maybe it's
That's
you.
not good.
Yeah.
That's not good. You don't want that to happen.
What if we buttressed it with the chair or something? If there's a chair on the other side over there, I can pull over.
What's different between now, last time?
It's,
it
I
was
think
fine.
that bottom thing is, oh, is it back in? That was messing up.
We need to-
So there's something going on with
I
that.
can- We can lower it back.
But I can help mess with it. I just want to make sure this is set up.
Nobody has a
For
screwdriver,
Eric.
do they?
I do not.
You could put a chair. These are all like, these are all.
Yeah, there are chairs that can be moved around. I grabbed this one right here.
Yeah.
That's what I'm wondering. Could also put one in front of it. Yeah,
Why is it not showing up? Our PowerPoint is what I want to know. Okay.
We got a chair behind it,
Thank you.
so hopefully that keeps it up.
Now I just gotta put that thing back. Show the parts.
Might it have anything to do with these USB connections? And that's just for the mouse or the controller.
Do you use one of these?
I don't. Um, We're restarting the computer now?
Oh, yeah.
I don't think so. Can try.
Do we have a printed copy of the?
Eric didn't. Mm-mm.
Says, let's get started on here. See it, like, okay.
Hi, Steve. Can you hear me?
Yes,
Is that working? Did you try to connect it yet?
I put in the code, now it's asking for a password at the
Okay,
end.
I sent it to you in the email.
Well, I got the session code. Oh, I
Right.
got you. I see what you're saying.
Okay, thank you.
That didn't work.
Really?
Yeah. Yeah, the password's not working.
That's interesting because I have it up on my phone and it shows that I'm connected. So maybe you didn't enter it right? I don't.
Yeah, because I got to the last box where you enter that,
Finding.
and it's not accepting it.
I can't see what the screen says, so I'm not sure. Could you just try to enter it again? I'll see if there's another court reporter in the building that could run down.
Yeah, I'll just try it again.
Okay, thank you.
No signal.
It's not finding.
Okay, you're up here. Sherry?
Thank you, Steve.
Okay,
And I can hear you, so that's great.
okay.
We have a hard copy. You know, he doesn't go first. Might try to get a hard copy for the job. Here.
What is that computer?
I don't know. Can I try your computer
Yeah,
to see
sure.
if it'll pull up yours?
Yeah, it's just logging on.
Maybe it's my computer.
Thing is, I don't have the,
It worked last time.
I don't have the presentation on.
That's fine, even if we could see if your display will pop up.
Right, so
If we
I'm,
could just see if anything pops up on your computer,
okay.
that would be great. Do you have a port on that
Um,
side?
I don't think okay, yeah, I do have USB on this side. Thought that was HDMI for a second.
Works just fine.
So I could run to the office and print something out too. That would be helpful.
We're having technical.
Fine.
Hey, James, you brought waters again.
I bring what?
Yes, I did.
You're a good person.
Yeah.
Sorry.
No.
I forget everything I need to know. I can be here. Thanks so much.
All rise. Superior Court for the state of Washington is now in session. The Honorable James J. Dixon presiding.
Please be seated. Thank you. Court is back on the record in the matter of State of Washington versus Tim Eyman et al. Cause number 17-2-01546-34. Court will continue hearing closing arguments this morning, starting with the closing argument of Mr. Eyman. Mr. Sanders appearing on behalf of Mr. Eyman. Good morning, Mr. Sanders.
Good morning, Your Honor. Can you hear me okay?
I can, thank you.
Your Honor, I would like to start where I left off, discussing the court's non-monetary relief order of September 13th, 2019. Then I'll talk about some of the constitutional issues which not only underlie this whole case, but shape the statute and help us to understand the provisions of the statute. I'll talk about some of the specific points raised by Mr. Newman in his argument, and finally discuss the state's proposed penalties and injunctive relief. I appreciate the court providing time for extended argument here, but when I finish, I'm sure there'll be many topics that I have not addressed. So I'll try to keep that in mind, Your Honor, that this is not intended to talk about everything in the world. The court's September 13th, 2019 order for non-monetary relief stated Mr. Eyman failed to report $766,000 in campaign donations that he had a duty to report because he is a, quote, continuing political committee, close quote. This order denied Mr. Eyman the opportunity for a fair trial, or any trial for that matter, on this issue. It was in the nature of a default judgment. The court entered partial summary judgment based on its September 13th order. Based upon this order, the state now wants to fine Mr. Eyman over $1 million and subject him to reporting requirements as a continuing political committee for the rest of his life. I have addressed this topic before, to Your Honor. However, important new facts were disclosed in the trial. First, there was no specific prejudice shown to justify the order, just exactly the opposite. And secondly, the state seeks to extend the order beyond its scope to include even child support payments paid after the order was entered. To justify such an order, a case law provides there must be the presence of three different elements. First, there must be a willful and deliberate refusal to obey a discovery order. Second, the party's actions must substantially prejudice the opponent's ability to prepare for trial. And third, the trial court explicitly considered a lesser sanction. I'd like to focus my comments on the second criteria, that is, the party's actions substantially prejudiced the opponent's ability to prepare for trial. Substantial prejudice is always required to justify such an order. It is never presumed. There are a number of cases that stand for this proposition, among them Burnett versus Spokane Ambulance, 131 Washington 2nd, 484, Marina Condominium versus Stratford, 161 Wash App, 249, and Rivers versus State Conference of Mason Contractors, 145 Washington 2nd, 674. These cases and other authority required a detailed record of the facts of prejudice and detailed findings so that there can be appellate review if necessary. In this case, the record to justify the order for non-monetary relief was the Perkins Declaration of September 5, 2019. He called it his first declaration, and the Attorney General motion of the same date. Near the end of my last oral argument, the court stated on the record that it took the matter very seriously and spent a great deal of time on it. The court stated, and I quote, "The court got the moving papers far in advance," close quote, of the hearing. So I would take it to be obvious the court not only had the declaration of Perkins and the motion of the Attorney General, but it studied them and it relied upon them. If my assumption is wrong, please, I invite the court to correct my misunderstanding. Here, the prejudice alleged was Mr. Eyman withholding the identity of donors based upon the Perkins Declaration of September 2019. The state's brief in support of the order on page 14 claims, and I quote, "These contributions go by the very heart of the state's case. Without the names of the donors, the state cannot ask them for the purpose of the donations." The claim was, of course, that Mr. Eyman was withholding the names of the donors. The declaration of Mr. Perkins at paragraph 32 states, and I quote, "The best example of how the Eyman defendants' longstanding misconduct in discovery has impaired the state's ability to prepare for this trial is their concealment of donor identities." Concealment of donor identities. This is the showing of prejudice which served as the basis for the court's order. However, at the trial, Mr. Perkins admitted that he had to cancel checks for all donors included in the $766,000 for a year prior to September 13th, 2019. He had the names, addresses, amounts, dates, phone numbers, etc. of each and every donor. I believe the court had the right to rely on his declaration under penalties of perjury and did rely on that declaration to accurately state the facts. However, now we know the declaration and motion were false. Names of the donors were not withheld from the state. It had them all. Every canceled check, name, address, phone number, amount, and date. Mr. Newman began his argument talking about how my client had been fibbing for the last 20 years. But I'm not talking about fibs. I'm talking about perjury. And it appears that the Attorney General, Robert Ferguson, suborned that perjury. The declaration of Perkins is on his pleading paper. He is an employee of the Attorney General, and he made this declaration on behalf of the Attorney General. So we're asking the court to do two things. One, find the truth, factually find that the statement is false and misleading. And secondly, deny the state the benefit of this order obtained through its own misconduct. We ask the court to vacate the September 13th order and give us a fair trial on the merits. If the court didn't know this was a lie before, it knows it now. Also recall our motion to reconsider the order of September 13th, 2019 was denied summarily by the court. But attached to that motion for reconsideration was an authorization for every single one of Mr. Eyman's bank accounts, the same ones that they already had and more, and that Mr. Perkins used those authorizations to construct Exhibit 352, claiming that Mr. Eyman had another $71,000 in unreported donations that the state wants to fine him for. It is a lie that the state didn't know his donors, and now this court knows the facts. And I believe that it is also a fact that we spent 7 or 8 months supplementing interrogatories, but 100% of the state's case presented at trial had nothing to do with those supplements. As of September 2019, the state's discovery was virtually complete. I'd like to address some constitutional principles that should be recognized by the court in the construction of this statute and should ultimately govern the disposition of this case. Our trial brief and our response to the state's motion for partial summary judgment sets forth the constitutional concerns predicated on the First Amendment. We encourage this court to read and study as many of these constitutional cases as it can, Not only will this enlighten the court on the relevant constitutional principles, but it will demonstrate how this statute was carefully and narrowly drafted to avoid constitutional problems when it is properly applied. But the state urges the court to apply the statute in a way it has never been applied before, and contrary to its express language, rendering it unconstitutional if it is applied as the state proposes. The act is subject to strict or exacting scrutiny, according to Buckley versus Vallejo, 424 U.S. at 77 and 78. The only legitimate purpose of the Fair Campaign Practices Act in the context of ballot measures is voter education. That is, specifically disclosure of direct campaign contributions and direct electoral campaign expenditures. Buckley makes the distinction between direct campaign financing and issue advocacy. Issue advocacy and advocacy of a political result cannot be constitutionally regulated because it is core political speech. If the statute does not unambiguously limit itself to direct campaign finance reporting, it is unconstitutionally broad and unconstitutionally vague. Although properly read, it is limited to direct campaign contributions and expenditures, and that's how it should be applied. Buckley held that the statute can only be constitutionally applied, and I quote, to reach only funds used for communications that expressly advocate the election or defeat of a clearly defined candidate. This reading is directed precisely to that spending which is unambiguously related to the campaign of a particular federal candidate, close quote. Of course, here we're talking about a ballot measure, but the principle is the same. If the Fair Campaign Practices Act can be applied as argued, Mr. Eyman's fundraising for personal expenses, it is unconstitutionally vague and overbroad. It regulates core political speech, which cannot be constitutionally accomplished. Buckley emphasizes, and I quote, compelled disclosure in itself can seriously infringe on privacy of association and belief guaranteed by the First Amendment, close quote. The importance of private association was also the holding of NAACP versus Alabama. The right to anonymously associate and pool money is constitutionally protected. Here, the US Supreme Court set aside hundreds of thousands of dollars in fines for refusal for the NAACP to disclose its members and contributors. Tim Eyman was held in contempt and fined for doing much the same thing. When the identity of the interveners was disclosed to the state, it threatened them with hundreds of thousands of dollars in attorney fees. Anonymity is important to the First Amendment. Reporting requirements are subject to strict scrutiny, and I'm looking at Utter versus BIAW, 182 Washington 2nd, 398. The only constitutionally sufficient interest is the substantial interest to disclose electoral campaign contributions and electoral campaign expenditures. There is no constitutionally sufficient interest to justify forced reporting of the finances of an officer of a ballot committee. And the statute on its face does not require that, although the state would. Recall, personal financial reporting is required of candidates pursuant to section, 235, who are required to file an F1 form, but not officers of a political ballot committee. The public has no interest in their finances. Probably the reason is that candidates continue in office and are subject to corruption, whereas officers of a ballot committee are merely sponsoring the measure. Once the measure is enacted, they have no further involvement with its enforcement and no discretion with respect to its enforcement. Aside from all that, even if Mr. Eyman were properly under the statute required to report, it is unconstitutional to subject him to unconstitutionally onerous reporting requirements. I'm looking at FEC versus MCFL 479 US 238. Mr. Eyman, as a continuing political committee, would be required to report every financial transaction for the last 8 years, thousands of them, and of course, all of them into the future. Moreover, he could not use his own money for personal expenses, that's barred by the statute, and would be required to hire a treasurer. He wouldn't be able to make any decision about how to spend this money. In short, he could not live without abandoning his political activism, which is the state's motive, not respecting the rights and following the law and protecting the rights of this citizen. That the state wants the court to misapply the statute is apparent from its oral argument. For example, Mr. Newman argued at 1 hour, 25 minutes into his argument, quote, "If you are getting paid to allow you to do advocacy work, you have to report it," close quote. Absolutely not. That is core political speech, not an electoral campaign contribution. The statute doesn't require it be reported, and the Constitution provides Mr. Eyman a First Amendment right not to report it. And it provides the right of free association and anonymity to the donor as well. Now to reply, Your Honor, to some of the state's more specific points in its argument. Much of what I have said today and on January 7th pertains to and is a refutation of what the state stated in its oral argument. However, I will present some specific rebuttal on some specific facts. The state starts by talking about data bar and claims that data bar refunded money directly to Mr. Eyman and it was improperly reported. However, data bar is never mentioned in the state's amended complaint. It is not their claims are itemized in their amended complaint. Data bar is not one of them, and it is not properly before the court. Moreover, the record shows that the transaction was reported by the campaign treasurer, not Mr. Eyman. Nevertheless, Mr. Eyman tried to amend the report, but the PDC would not permit him to do so because he was not the treasurer. This illustrates the very first point in our argument, and that is that Mr. Eyman not only has no reporting responsibility under the statute, but he cannot report anything under the statute. The state spends quite a bit of time discussing matters that are outside the statute of limitations. Recall the statute includes March 2012, but nothing before it. But a lot of the state's arguments focus right there, prior to 2012. For example, the state tries to prove a 2012 kickback by citing a 2010 email suggesting a 50% signature gathering price bump in an earlier campaign, which never materialized. It never happened. The state mentions various gifts received by Mr. Eyman prior to 2012. But during that period, that is not only outside the statute of limitations, but people have a right to give Mr. Eyman anything they want. And unless it is an electoral campaign contribution, it need not be reported by anyone, not even a campaign committee. The state claims that Initiative 1185 produced a kickback to Mr. Eyman, but there is no proof of that. All campaign payments to Citizen Solutions were reported and properly so, every one of them. Apparently, the state argues they shouldn't have been reported as payments to Citizen Solutions, but rather as payments to Tim Eyman. I guess this is a novel, a bizarre approach to the case. It is not something that any rational campaign treasurer would even consider when reporting payments to Citizen Solutions for signature gathering. And I might add that this was not a phony or fake. $320,000 of the 320,000 signatures were actually gathered by Signature Solutions. And had they not been, the measure would not have qualified for the ballot. So the state claims that $308,000 of payments to Citizen Solutions were not to Citizen Solutions, but to Mr. Eyman. But we know that every penny listed paid to Citizen Solution was paid to Citizen Solutions. And we know that Citizen Solutions can do anything it wants with its money, and it need not be reported. The state goes outside the statute of limitations to talk about $270,000 payment requested by Mr. Eyman. This was never paid. The consulting agreement ultimately entered into in July of 2012 with the Citizen Solutions was not $270,000, but $308,000. There is no connection between the two figures. The state does not deny that Citizen Solutions was paid fair market value for the signatures it collected, however, tries to construct an argument it was paid too much. It compares gross amount paid to Citizen Solutions with the net amount paid to individuals on the street collecting signatures, but it fails to make the distinction or the disclosure that Citizen Solutions hired sub-vendors who in turn made a profit and then hired individuals on the street. So when we say an individual on the street was paid $1 or $1.50, that is not what Citizen Solution had to pay the sub-vendor or coordinator to obtain those signatures. But in any case, money paid by Citizen Solutions is not reportable by Citizen Solutions or by the campaign. If the Attorney General or the court thinks that that would be a nice provision, the argument should be addressed to the legislature, but we have to follow the statute as written. The state faults Mr. Eyman for raising money from potential donors, claiming he had more money than he was letting on. This, however, does not violate the Act. The Act only requires disclosure of campaign contributions and campaign expenditures. They were, and they were reported by the treasurer. There is no personal financial disclosure requirement for a ballot measure officer, only a candidate. A candidate fills out an F1 form pursuant to Section 235 of the statute. This is a big distinction in the Fair Campaign Practices Act between how they treat candidates and how they treat ballot measures. The state claims that Stan Long was a ministerial treasurer. However, the state has prosecuted ministerial treasurers such as Barbara Smith for improper reporting. Moreover, if Stan Long is a ministerial treasurer, that doesn't mean Tim Eyman has any reporting requirements whatsoever. They're just not in the statute. He is not a treasurer, ministerial or otherwise. The state claims that the consideration for the consulting contract of July 2012 in the amount of $308,000 was not for future work. However, all testimony from the parties is to the contrary. But even if it was an outright gift, that doesn't mean payments from Citizen Solutions to Mr. Eyman or Watchdog were campaign contributions. The Citizen Solutions was paid by the campaign for signatures, and obviously they got them. 320,000 of them were turned in. Citizen Solutions made a profit and can do anything it wants with its profit. There are no reporting requirements. There's no regulation on how much of a profit they make. There is no bailout if they don't make any profit. This is a free enterprise system, at least to this date. Period. The committee paid Citizen Solutions a final installment on July 6th to secure the delivery of these signatures. They paid Citizen Solutions what Citizen Solution was owed. After that, the money was Citizen Solutions, and they could do what they wanted. The state claims that Mr. Eyman made a concealed loan to citizens in charge so it could make an in-kind contribution to the 517 campaign. It claims this is concealment contrary to Section 435, but that statute does not apply to loans. A donor need not disclose, the donor, that is citizens in charge, in-kind donor, need not disclose the source of his money or the maker of the loan. A campaign committee does not disclose the source of a loan to a contributor. This is the way the statute is written. That's how it's worked. That's how it's always been applied. The state claims a loan, by definition, is a contribution. Remember, they were talking about the contribution definition. They say the very first word is loan. However, you have to read more than the first word. Their claim is false. A loan for full consideration is not a contribution. That's in section 005, subpart 15, subpart A, subpart single I. This loan was 100% repayable. If there was a default in part on repayment, it is still a loan. A loan is a loan. The state claims the loan was paid back by, quote, other contributors to the 517 campaign, close quote. Not so. The loan was paid back by citizens in charge. Mr. Eyman asked his friends and supporters to donate to citizens in charge, hoping that they would get citizens in charge more money, which it could use to repay the loan. Repayments to Watchdog from citizens in charge had nothing to do with 517. 517 did not repay the loan, nor did donations to citizens in charge from Eyman, nor did donations to citizens in charge from Eyman's friends. The state claims that Mr. Eyman received concealed payments for political work, close quote. The state says checks labeled legal defense counted as political campaign donations if not deposited in Eyman's legal defense fund. However, the state takes the position that legal defense funds are not reportable at all. State Exhibit 352 recounts $71,000. The state says this is for, quote, political work, close quote. The statute doesn't require reporting donations for political work, only for an electoral campaign, and that is specifically contributions to and expenditures by an electoral campaign on the campaign. This approach by the state violates the First Amendment, and it is also outside the scope of the statute. Mr. Newman, in his argument, said, and I quote, I believe I quoted this before, quote, if you are getting paid to allow you to do advocacy work, you have to report it, close quote. No, you don't. This is core political speech protected by the First Amendment. Mr. Newman goes on to another section of his argument, which he entitles reporting violations. The state wants the court to find Mr. Eyman a, quote, continuing political committee, not as a discovery sanction, but as a matter of fact. But note that the state rarely says continuing, close quote, when it talks about a political committee, because the state knows that Mr. Eyman cannot be characterized as a continuing political committee under the definition in the statute. And no individual anywhere ever has ever been so characterized. The statute requires an expectation of contributions to a campaign. There were none, as well as a organization which received those contributions, which is part of the definition of continuing political committee, is plainly not met by a single individual. However, we agree that the September 13th order should be vacated, but there is no basis to conclude on the merits of Mr. Eyman's is a continuing political committee. He is not a ballot measure, and he is not an organization. He doesn't seek or spend money for campaigns. End of the story, period, full stop. Mr. Newman states, and I quote, what matters is he has expectation of receiving contributions to further electoral goals, close quote. However, that is not the statutory or the constitutional standard. Furthering electoral goals is very much like the problematic language discussed in Buckley that unconstitutionally swept in protected issue advocacy and was disapproved by the High Court. The state can't live with the statute as the statute is written. The court has to be particularly careful to read the words of the statute and understand the difference between what the statute actually says and what the state's argument is. The state says, and I quote, "Fighting for taxpayers is a political goal," close quote. That's at 1 hour and 30 minutes into the argument. However, fighting for political goals is not a subject of this statute, and it would be unconstitutional if it said that. There's a lot of people that fight for political goals. That doesn't mean that they have to report everything that they do in their life to the Public Disclosure Commission. Mr. Newman also used an interesting example from Eastern Washington, where Mr. Eyman apparently appeared at an outdoor meeting, and a friend of his passed the hat. And Mr. Eyman characterized what he said as, quote, "This collection is for Tim for all he's done for us over the years," close quote. This is not an election campaign contribution. It is not reportable. It is the essence of protected speech, and this illustrates the unconstitutional approach of the whole subject by the state. The state defends its position, saying that this illustrates the, quote, "expectation of receiving contributions," close quote. Sure, but not for an electoral campaign. Only that qualifies, not just a contribution for any purpose. There's another distinction the state fails to make about what the statute says. The state points out that there was a $308,000 consulting agreement, and that wants to fine Mr. Eyman that amount for entering into the consulting agreement. But that was Citizens Solutions paying its money to Eyman. It's not reportable. Then the state claims apparently campaigns should not have reported paying Citizen Solutions money for signatures. So how does that work? It did pay Citizen Solutions money for signatures, and the signatures were provided. Is the state saying that it should not have reported paying Citizen Solutions for signatures, but it should have just reported paying $308,000 to Mr. Eyman? That doesn't make any sense. It's counterintuitive. It's not in accordance with the facts of the case. If the money was for Tim and reported as such, that means Citizen Solutions would not even get the original contracted $1,050,000, since the bumps only accounted for $160,000, not $308,000. The state's theory doesn't make sense. Moreover, if Citizen Solutions wants to give Mr. Eyman $308,000 for any reason, that's its right, and it's not reportable. The state wants to fine Mr. Eyman $182,000 for its loan to Citizens in Charge, or I should say the watchdog loan to Citizens in Charge, claiming it was really loaned to 517. But those are not the facts proven in this record. It wasn't loaned to 517, and there was no duty on Watchdog to report this, nor a duty on 517 to report it either, nor a duty of Citizens in Charge to report the receipt of a loan. We know the loan wasn't to the campaign. We have the canceled checks to Citizens in Charge. All of this is a fantasy made up by the state in its convoluted approach to the case. The state wants to fine Mr. Eyman $832,000 for gifts from his friends as living expenses. This claim is unprecedented. It's bizarre. It is not supported by any precedent in this state or any other state ever. That is a continuing political committee issue, which I have previously discussed. The state wants to fine Mr. Eyman $1,250,000 for not reporting monthly as a continuing political committee. As previously discussed, he is not a continuing political committee and has no responsibility to report as a continuing political committee. The state wants to fine Mr. Eyman $23,000 for the data bar refund due to an alleged reporting error. But Mr. Eyman is not the treasurer. It is not in the amended complaint, and he can't amend and he cannot amend previous filings by the treasurer, although he tried. In total, the state wants to fine Mr. Eyman $2.6 million and then treble it. This is an outrageous sum, truly out of proportion to any like case under the PDC. Then Mr. Eyman says, Mr. Newman says, Mr. Eyman is a very wealthy person who lives in a $1 million house on the golf course, and that people have a right to know how much he is making and his net worth. Well, let's start with what I call a fib. That's the word Mr. Newman used over and over again regarding Mr. Eyman, and it got on the front page of the Seattle Times, fibbing. Mr. Newman knows Mr. Eyman does not live in a $1 million house on the golf course. Mr. Eyman rents a condo in Bellevue, and his rent payments are listed in Exhibit 352. The house in Snohomish County is not where Mr. Eyman has lived since the state broke up his marriage. That's Karen's and the kids' house. Mr. Eyman's finances are well known now to the state. It gets monthly reports from the bankruptcy court. Mr. Eyman has about $40,000 in the bank, and from that must pay the state $10,000 every month to avoid default, as well as other listed creditors in the bankruptcy petition. When Mr. Eyman was on the stand, I attempted to go into some of his personal finances. The state objected, and the court sustained the objection. Mr. Eyman's financial shape is in reality untenable, and Mr. Newman knows it. As to the claim that the public has a right to know about Mr. Eyman's personal finances, there isn't any. There isn't any right to know that. Mr. Eyman is an officer of a political committee. He is not a candidate. Unlike a candidate, he need not provide any personal financial disclosure according to Section 235. He need not file an F1 form. For the reasons I outlined last time, personal financial disclosure is not required from a ballot committee officer because the public has no legitimate interest in that information. But the state doesn't agree with the statute and wants to say it is something it isn't. I suggest that the remedy for the state is the legislature, not this court. A further word about penalties. The penalties urged by the state are maximum penalties. The statute sets no minimum penalties. We don't think any penalties are appropriate at all as a matter of law. However, if the court were to consider penalties, it should also consider Section 750, Subpart D, Subpart XIII, which directs the court to consider penalties in factually similar cases. The penalties argued by the state are grossly disproportionate to those in similar cases. We got into this earlier with respect to exhibits, and it was my understanding at that time that if the court were to find liability, we would take this up separately. However, I will give you two examples of similar cases. These two examples are relevant because they involve individuals, not massive corporations, and they involve dishonesty. The fines in these cases are a fraction of what is being sought in this case. There was no injunctive relief to speak of imposed in these cases, in contrast to the AG's announcement that he would like to wage something like World War III against my client. First example, the Aaron Reardon case. Mr. Reardon was the former Snohomish County executive and was fined $4,200 by the PDC for several reasons, including the use of county resources to campaign and raise money, the use of taxpayer-funded staff on county time, and compete to harass officials he designated as his enemies. The case was investigated 3.5 years by the PDC. The PDC chairwoman, Katrina Assay, told the Everett Herald, and I quote, I feel like this is one of the most egregious cases I've seen. Like I said, there was a $4,200 fine, no equitable relief. Another case, which I think is analogous, is Moxie Media, because it involves roughly the same amount of money as our case, that is $300,000. This case involved a successful false flag campaign to deceive voters into rejecting an incumbent candidate. The campaign intentionally concealed the source of its contributions to make it appear it was from one side when it was in fact from another. The deception caused the defeat of an incumbent. The fine was $110,000 with no ongoing limitations on political activity, despite lying about sources of their financing to successfully influence an election and deceive voters, who were in fact deceived. The only equitable relief granted by the court was mandatory training. Lastly, the state argues for injunctive relief. Before we discuss this, I think the court should recognize that characterizing Mr. Eyman as a continuing political committee is something different from injunctive relief. This injunctive relief, the state wants to add on top of that. If he were characterized as a continuing political committee, he would have, through his treasurer, he'd have to hire a treasurer. He couldn't do it himself. He would have to hire a treasurer who would report all income to the political committee and all expenditures by the political committee. There are no exceptions. There's no exception for a W-2 or whatever. Everything that goes into the committee and everything that goes out of the committee has to be reported. And none of that can be used for personal expenses. That's also in the statute. In fact, it's part of the government's claim regarding the receipt of the $308,000. So characterizing him as a continuing political committee creates an impossible situation for Mr. Eyman. He simply couldn't live. But now they want to add on top of that an injunction. This injunction would put Mr. Eyman under this court's supervision for the rest of his life, unless he abandons all political advocacy, which is obviously his First Amendment right to participate. The state seeks to enjoin him from, quote, directly or indirectly as to why someone should donate to a campaign committee or how the contributions would be spent. This is as broad as it is vague. Any promotional speech on the part of Mr. Eyman would be subject to sanction and would be chilled. He cannot do business, according to the injunction, with any vendor, quote, directly or indirectly, who provides or might provide services to an associated political committee. These are all free speech activities that the state would like the court to enjoin Mr. Eyman from participating. The state wants an injunction saying that he must report all income of whatever nature or source, unless from a W-2 employer. So I guess that the state's position is Mr. Eyman cannot seek self-employment without reporting all aspects of that self-employment. The state says that he should be permanently enjoined from, quote, managing, controlling, negotiating, or directing financial transactions of any kind for any committee, close quote. So I guess he can't negotiate a printing contract or a signature gathering contract or change phone numbers or do anything. He's in a straitjacket. You cannot participate in a free society with those kind of restrictions. The list goes on and it goes on, and I will not attempt to summarize all of it. There's just too much there. Such an injunction would eliminate his free speech activities and eliminate his ability to meaningfully participate in any ballot measure campaign, which is exactly what the Attorney General wants. This is in combination with reporting every financial transaction associated with characterizing him as a living, breathing, continuing political committee. And it leaves him no room to breathe to participate in a free and democratic society. And I believe that we see references to no room to breathe in cases like NCAA or NAACP versus Alabama, that freedom means that you have to have freedom to breathe when you're exercising your free speech rights. Here, there is none. So, in summary, the case is designed to eliminate Mr. Eyman as an advocate for less taxes, smaller government, and a free society. It will put him in virtual jail with this court as the jailer, with unending court hearings in the future to supervise every aspect of Mr. Eyman's life. In conclusion, our statute simply does not support the state's claims. As a reporting statute to guide men and women of common understanding, it must be applied in that way as well. This is a statute which exists in the heart of the First Amendment political advocacy and must be applied as clearly written in a common sense way. It is not a statute which deals with original and bizarre theories, but rather simple reporting. That is anything but the state's case. It requires campaign reporting of election contribution and election expenditures. That's it, only it. Only the treasurer has the reporting responsibility. Mr. Eyman is not a treasurer, and he need not and could not report anything. Stan Long reported everything he was required to report. The state's claim regarding 2012 reporting is meritless. So to the proposition that Mr. Eyman is or could be a, quote, continuing political committee cannot be squared with the requirement that contributions be solicited only for actual election campaigns, not individuals active in the political process, which is what Mr. Eyman is. This is not a case which tests whether the court agrees on every point or every action with Mr. Eyman, but rather if he has clearly violated the law as written. He didn't. The state's claim should be dismissed with prejudice, and Mr. Eyman should be awarded his reasonable attorney fees pursuant to Section 780. Thank you very much, Your Honor.
Thank you, Mr. Sanders. Court's going to be in recess until 10:03, after which the court will invite the state to present rebuttal argument. Thank you.
All rise.
Oh, I got it. Sorry. Nothing wants to work.
Do you think you'll need my computer or
No.
will you?
I have Jenny coming with a torch projector.
Oh, great.
Not trying to get the torch, sorry. It worked just fine 2 weeks ago. Like, I don't understand.
If
what
it doesn't
is.
work, it doesn't work.
I know, but this is like, these are my worst nightmares of my job. FYI. And I've tried every source possible.
worries. Okay.
Yes.
I agree, Steve.
Sure, 2 minutes. Do you want to come up here and see if you can pick it up?
Yes. Judge Dixon, it looks like our projector's not working, we just got a new one that's gonna take a few more minutes to get going. We can have, 5 more minutes.
Oh, wow.
Your laptop doesn't have an HDMI. I have to use this. So I don't know, like, but last week it worked just fine.
That laptop.
Do you need one with an HDMI?
I might need to in a minute to try this new one. Okay, do you think you'll let us?
Yeah, I just asked you.
Okay. What's wrong with that?
Comes to worst, we can PDF this. Is there any animation or anything in this?
Could be anywhere.
I don't think so. It's just slides.
If worst comes to worst, we can PDF it and put it on an iPad.
All our stuff in your way there.
No, you're.
Um,
I love you. It's so funny, I just happened to be there. With background.
The issues, the computer, Tony has one too.
Yeah, we tried his earlier too.
Table's in the way.
Yeah.
Jessica, can you unplug yours and put it back in? Let's try the GA.
That way too. I do. I do have an iPad.
Copy, but it is the exact copy of what would be the final. So we would need your signature.
Yeah, you want me to sign this one?
Oh, I didn't know if you wanted.
I do have an iPad, it's
You gave it to us the last time, so I
Yeah.
think we're in good shape.
So you want to
It's
sign
not uploaded on
this?
They have this
Let me use this one as your original. Then I was just trying to, and I'm. we can wait till you-
All you need is a signature?
Yeah. And then you- This one is just you want to return or can you destroy? And it isn't, so like, you could always like initials or something. I'm not sure if they can check anything. Mr. Sanders? Can you hear me okay?
Yes, I can. Thank you.
I have the final exhibit list, which if you were here, I'd ask for your signature when we're done. The only other way I know to do it is when we're completely done for the judge to ask you if you approve, and the judge could indicate that you did. I don't know how else to do it.
Any possibility you could email it to me or?
Just a second.
No.
What do you use for email address?
It would be rsanders@goodsteinlaw.com.
Okay, I've got that. Yeah, I can email it to you and then you could review it, and when the judge asks you, you could verbally confirm.
You're not hooked up to the internet.
And then the judge could, I think, make a note that you approved it.
Well, I can't watch this video and pull up the email all at the same time. If I
Oh, no,
could,
I'll just start by emailing it to you and we'll go from
Okay.
there.
good, thank you.
Thank you.
Yes. No, exactly. Thanks for bringing over the new chapter. How's it going?
No, let's just give up. Sorry, I'll just do it without.
Are you sure?
Yeah, I'd rather
We're
get done.
close. Okay, sorry.
No worries.
It's something with
Jenny, thanks for coming.
both of them. They're not, nothing's working.
Yeah, let's just shut it down and we'll get started. Great, thanks. That's fine. No, it's fine. I'd rather get going.
All rise. Court is in session.
Please be seated. Thank you.
Mr. Newman, rebuttal argument on behalf of the state of Washington.
Thank you, Your Honor. I didn't introduce myself this morning. For the record, Eric Newman for the state of Washington. Thank you for the extra time. We were trying to get we switched out projectors. We couldn't make it go, so we're going to go without. I don't think it's that big a deal. You've seen a lot of the information that was in there in our presentation a couple weeks ago. So there's not a lot of new information in there. But what struck me about Mr. Sanders' closing is that there weren't any exhibits. I didn't really talk about the exhibits. The state put dozens and dozens of exhibits in front of Your Honor, and in fact, dozens of exhibits in the PowerPoint during our closing, and none of them are addressed. Well, Mr. Sanders gave kind of a short shrift to a couple documents. Defendant Eyman wrote an email to his co-conspirators in the spring of 2012 saying, when it comes to the 270, I'm working hard to get it for myself. So he admits in an email that he is actively doing something illegal. And Mr. Sanders' response to that is, well, when they eventually did pay the kickback, it was a different number. So you should disregard that. So he's dismissive about a few of the documents, but ignored many more. The vast majority of them. Didn't deny the conniving, didn't deny the conspiracies, didn't deny that he literally wrote down his conspiracies over and over again. Instead, his argument is, even if he did all that stuff, it's not illegal, that there's nothing the state can do about it. That's his argument. So his argument is, in 1972, the voters passed the Fair Campaign Practices Act. And in the 50 years since then, the legislature has developed the law into this huge statutory chapter. The PDC has given guidance on it and rulemaking on it. The courts have interpreted it, and for 50 years, since 1972. And in all that time, nobody noticed a huge, huge glaring loophole, and that is, you can do whatever you want as long as you're not the treasurer. So that's his argument, that the whole statute, none of it applies if you're not the treasurer. So no matter how many false reports Defendant Eyman approves and has sent in, no matter how many contributions he takes in and doesn't report at all, no matter how many expenditures he makes on behalf of the 517 campaign through his loan, there's nothing the state can do about it. Even though it's illegal, even though it's specifically addressed in the statute, there's nothing the state can do about it because he's not a treasurer. Of course, that's not the law. So we're going to talk about three kind of broad categories: the I-1185 campaign, the 517 campaign, and whether or not Defendant Eyman is a political committee. With the I-1185 campaign, the whole argument is he wasn't the treasurer. That Stan Long was a qualified treasurer, and Stan Long did the reporting, and Defendant Eyman had no duty to report. What we know is that Defendant Eyman wrote out his plan to launder money through Citizen Solutions in an email. We know that he followed up on it. We know that he was eventually paid about the same amount. It was actually more, but about the same amount. So all those are undisputed facts. And his argument is that the statute has all of these obligations for treasurers and only for treasurers. He's right on one point. There are obligations for treasurers, but there are obligations for officers too. There are obligations for people. While Defendant Eyman is not a treasurer, he is a person, which is specifically addressed in the statute, and I'll take you through that. But we know that the $308,000 was reported by the I-1185 campaign as paying for signatures. There's no dispute about that. But we also know is that it was not actually spent on signatures. It was spent on a payment to Defendant Eyman. And that reporting that it was for signatures was based on Defendant Eyman's direction to the treasurer that this is for signatures, and to to his co-committee members, the other officers, that it was for signatures. So defendant Eyman hid that fact. We know he hid that fact because he swore under oath that he never told Stan Long about the $308,000 payment to himself. He promised he did not tell him, and he said it was because it was none of his business. So we know all of that happened. But his argument is, this is Stan Long's fault. I can't be blamed for taking a $308,000 kickback. If anybody should be punished, it should be Stan Long. Stan Long should have to pay the $308,000 I took because he signed the report that said it was for signature gathering, and that wasn't true. The treasurer argument kind of falls apart when you actually look at the statute. And the reporting statute, which is 235, says each candidate or political committee must file with the commission a report of all contributions received and expenditures made. It doesn't say the treasurer. Now, to be fair, in 235 farther down, it does talk about the procedure for filing. It says the kind of forms and the days and who's supposed to sign it. But the committee is responsible for reporting, not just the treasurer. More importantly, the statute on penalties, which is subsection 750, does not mention treasurers at all. It says a person who violates any of the provisions of this chapter may be subject to a civil penalty. A person who fails to file a properly completed statement or report within the time required by this chapter may be subject to a civil penalty. A person who fails to report a contribution or expenditure as required by this chapter may be subject to a civil penalty. A person, not a treasurer. If the statute were exclusive to treasurers, one, it would be largely worthless, and two, it would have said so instead of saying a person. We talked a little bit about ministerial, the fact that Stan Long was a ministerial treasurer throughout the trial. And what we haven't talked about is what a ministerial treasurer is, and the law tells us what a ministerial treasurer is. There's a WAC 390-05243 describes what ministerial duties are. And among others, filing reports that have been reviewed and approved for filing by the candidate or political committee officer. So ministerial treasurer files the report, but it has to be reviewed and approved by an officer. Maintaining campaign finance and other similar records, including making them available for inspection upon direction by the candidate or political committee officer. Writing and depositing checks at the direction of the candidate or political committee officer. Communications, and it describes circumstances, a longer paragraph about circumstances of communications, but do not involve attending strategy or campaign planning meetings or portions of meetings with candidates or political committee officers. Ministerial treasurers are bookkeepers. They just do the paperwork. They're not responsible for the truth of what's in them. They have no way of knowing. They're actually not invited to the meeting by WAC. They're not invited to the meeting. They're ministerial, and that's what Stan Long was. Now, Stan Long was filing false reports. He just didn't know it. He was going on the information that was given to him by a campaign officer, Mr. Eyman. Now, of course, there's a judgment against defendant Eyman at the end of this case. It will not be the first time that a non-treasurer has been sanctioned under this statute. Of course, there are dozens of them. Most recently, the GMA case, which was just affirmed last year by the Supreme Court. GMA's treasurer wasn't the target. GMA was the target. GMA got the $18 million judgment against it. This is not even the first time a non-treasurer judgment has been issued against defendant Eyman, because he wasn't the treasurer in permanent offense back in 2002. It's not even the first time Your Honor has found that defendant Eyman violated the FCPA, even though he was not a treasurer in the tougher to raise taxes case. Getting to the loans, the I-517 campaign and the loan to I-517, Mr. Sanders said a couple weeks ago, the statute treats loans different from contributions. But in fact, the statute says loans and contributions are synonymous. And as he pointed out today, the word loan is the first substantive word of the definition of contributions, which include a loan, gift, deposit, subscription, etc. He says, well, you have to keep reading, because at the end of that paragraph, it ends with including personal and professional services for less than full consideration. So he seizes on that for less than full consideration, without pointing out that for less than full consideration is in reference to personal and professional services only. But even if it didn't, even if it did apply to the whole definition, it wasn't for consideration. This is a no interest loan with no payback date. No bank in the world would give you a no interest loan with no payback date. And that was the terms of the loan from the beginning. Defendant Eyman wrote it down. There's no payback date and there's no interest. Mr. Sanders said again a couple of weeks ago and repeated it today that you don't have to identify the lender if it's not a direct loan. But the statute specifically addresses that. 435 says no contribution, which includes a loan, shall be made, I'm skipping over some language, by one person through an agent, relative, or other person. You can't give a loan through somebody else. It's specifically in the statute. And a separate statute, 465, restrictions on loans says a loan is considered to be a contribution from the lender. The full amount of the loan shall be attributed to the lender. So the statute's pretty clear on this point, so I won't belabor it any further. And then finally, we have Defendant Eyman as a political committee and all of the issues that come out of that. First, when Mr. Sanders started talking about this a couple of weeks ago, he said it's important for the court to read the statutory language. The state could not agree more on this point. The statute's pretty clear, and the violations here are specifically addressed in the statute. The definition of political committee is easily met by Defendant Eyman, and we give you piles and piles of letters that he was sending out saying, I did this work on whatever, can you pay me for it? Over and over and over again. Mr. Sanders doesn't even address them, doesn't even talk about it in his closing, because it's an admission that he is doing something illegal. Mr. Sanders says under the statute, there needs to be an expectation that the money will be spent on elections. The money at issue here was not spent on elections. He said that a ton of times in his closing and throughout this case. But the GMA case, which is just last year, says there are two ways in which an entity may become a political committee. And this is old law, it's just repeated in GMA. And the first is expecting to receive or receiving contributions. And then Mr. Sanders quoted me today and said, well, Mr. Newman says contributions to further electoral political goals. He attributed that quote to me and said, that's not the law. I didn't make those words up. They're in the GMA case. I was reading it just then. I was reading it 2 weeks ago. The GMA case is very specific about to further political, electoral political goals. And lastly, Mr. Sanders said the money was not spent on electoral purposes. He said that many times, but the Utter case specifically says the ultimate disposition of the funds does not answer the contribution question. So it doesn't matter what he spent it on. Otherwise, He could just go into Voters Want More Choices bank account, scoop out a bunch of money that was undisputedly contributed to pay for a campaign. If he just takes it out and goes and spends it on himself, Mr. Sanders argues, well, then it's not a contribution anymore because he spent it on himself. Of course, that's not the law. So Mr. Sanders, a couple of weeks ago, talked about how the state's legal theory is made up out of thin air, and it dates back to the Stutzman letter back in 2002. It doesn't. It dates back to 2002 when defendant Eyman admitted he was doing this, what he has been doing here back in 2002, admitting that he was doing it on purpose, admitting that it was illegal. We put up his quote, "Permanent Offense," which was the 2002 case, "Permanent Offense, Inc. organization was set up to have a way to cover the fact that I was making money sponsoring initiatives, and none of my co-sponsors knew that was the case." That's in Exhibit 135. He admits what he was doing was wrong back then. He admits he continues to do it to this day, but now he says, well, it's not illegal because I'm not the treasurer. And finally, there's this argument about defendant Eyman can't be a continuing political committee because he's not an organization. So a couple things there. One, then he's a regular political committee. The requirements are the same, it's just how they're categorized, but the penalties are the same, the reporting requirements, as far as contributions coming in and expenditures going out, they still have to be reported. But he is a continuing political committee, and this argument about that he doesn't meet the statutory definition is a bit of a red herring. So we've already talked about this, but the statute defines a continuing political committee means a political committee that is an organization of continuing existence, not limited to participation in any particular election campaign or election cycle. And of course, a political committee, which is right in the definition, means a political committee that is any person. So the statute could be read, a continuing political committee means any person that is an organization of continuing existence. So, but they seize on that, an organization of continuing existence, and well, he's not an organization. Now, he's not an organization because he didn't follow the law, which requires him to file a statement of organization, which this court told him to do a year ago, and he still has not done. The RCW 205 statement of organization by political committees says every political committee, which includes a person, so it could say every person under these circumstances shall file a statement of organization. That's what the statute is talking about. And if you look throughout the statute, organization and person are kind of used interchangeably. And if you look at the definition of person, it includes organization. So they're used interchangeably with that throughout the statute. But if defendant Eyman had followed the law and filed a statement of organization, then he would have been an organization. So that section, the statement of organization section 205, it doesn't say anything about treasurers. The whole section is a paragraph long and doesn't mention treasurers. It says political organizations need to register. Now, defendant Eyman's argument is this circular interpretation that you can't hold me liable for violating the statute because I never complied with it to begin with. His argument is, if you never register, then you couldn't possibly have a treasurer, and if you don't have a treasurer, you can't violate the statute. It is, if there is any argument that Your Honor needs, any further evidence that Your Honor needs that injunctive relief is necessary here, it is that argument. So defendant Eyman, back in 2002, was found to have violated the statute. And the court, the Snohomish County Superior Court's effort to stop him from violating the statute, entered an injunction saying he can't be a treasurer. Now, defendant Eyman's argument is that that injunction didn't stop him from violating the FCPA. In fact, it immunized him from violating the FCPA. Because he is barred from being a treasurer, he can never again violate the FCPA. See the court's order from 2002. That's what he's arguing. Your Honor might remember a couple weeks ago when once again, defendant Eyman was told that he could not take pictures in the courtroom. We have been in front of Your Honor close to 100 times. I went back and looked, and we've been in front of Your Honor close to 100 times in this case. I can't count the number of times you have made clear that if you want to take pictures in the courtroom, you have to ask, and you have to be pressed. Over and over and over again, you have said that. But last week, I brought up the issue, and you said, can't take pictures in the courtroom, and he said, oh, I thought it was just videos. That kind of behavior, the I can't violate the statute because you told me I can't be a treasurer, or the, oh, I thought you said something different, is exactly why a careful, robust, meticulous injunction is necessary, and it has to be in writing. Because if we miss something, the creativity of the interpretation of this court's order will be used against it. That's why the state has offered such robust language. And finally, the penalty amount, $7.8 million. We gave you that number a couple weeks ago, and it's based on the trebling of a base penalty amount of $2.6 million. The $2.6 million is the penalty. That is the penalty that is necessary for the behavior that we're talking about here. The trebling, on the other hand, is punitive. If you don't treble it, then it's not punitive, it's just a penalty. You hit $2.6 million, you pay $2.6 million. The trebling is punitive, and the trebling is necessary in this case. It's necessary because contrary to Mr. Sanders, well, Mr. Sanders kind of gone back and forth on this. I am sure there is no case like this. I am sure there has never been a case with this length and this meticulous conniving and conspiracy to get around the FCPA. I'm sure it has never happened before. So constantly hearing, this is unprecedented. It is unprecedented. Nobody has ever violated this statute for this long in this many ways. The GMA case is a perfect example. The base penalty in GMA was $6 million because that's how much they hid. That makes sense. It was trebled to be punitive. The behavior in GMA does not come close to the behavior that's here. And the fact that GMA is an organization and not a person is not a relevant factor here. The only relevant factor is the behavior. The behavior is far worse in this case, and $7.8 million is not even close to the $16 or $17 or $18 million that the court could award in this case. $7.8 million is sufficient to address the issues that have been before you. Your Honor, I appreciate your patience in this very long case, in this very long trial, and that's all I have.
Mr. Newman, with respect to Mr. Sanders' argument on behalf of his client that the statute of limitations precludes the state from seeking any damages or remedies prior to March of 2012, what's the state's response to that argument?
To Your Honor, the $2.6 million amount that the state has asked for, move back up there, doesn't take into account anything that happened before March. But even if it did, it was an ongoing conspiracy. The discovery rules should apply And the statute of limitations was not pled in this case. And therefore, because it is a disfavored affirmative offense, it's waived.
And how about the argument from Mr. Eyman that the data bar transaction was not pled by the state, therefore the court doesn't have the authority to, not pled by the state?
Two things. One, it was pled by the state. The state doesn't have to lay out each transaction. The $400 check from Mr. Jensen was not specifically pled either. What the state did plead is that there has been a constant flow of contributions into defendant Eyman's pocket that have not been reported. So the state doesn't have to go one by one. But second, that specific transaction wasn't mentioned because we didn't discover it until discovery.
And lastly, the court will ask the state to respond to Mr. Eyman's argument that the injunction relief being sought violates Mr. Eyman's First Amendment constitutional privileges.
So, Your Honor, we've talked about constitutional issues many times before in this case, dating back more than a year now that we've been talking about constitutional issues. Over and over, the FCPA has been found to have been constitutional, and the requirements within the FCPA have been found to be constitutional. None of the sections that the state is relying on has ever been found to be unconstitutional under any circumstances, for one. And for as far as, give me a second, please. I think Mr. Sanders has painted a slippery slope situation to make it seem like this injunction would be unable to be overcome. The state has given very specific exceptions or ways that it could be addressed. So defendant Eyman, if he doesn't want to report every time he goes to get a latte at Starbucks, this can be avoided. He has to hire a treasurer. That is an agreed order that he can't be a treasurer. So that is a problem that he created. He is going to have to hire a treasurer. But if he had, and this is specifically laid out in the injunctive language the state gave, if he had an organization that took money in so he could go out and campaign and ask people to give money to his cause to compensate him for his work on initiatives, he could still do that. The money would be paid into his organization, which was run by a treasurer, not him. And then that organization could report payments to him for his work. It would work just like if a campaign manager, if a campaign hired a campaign manager and campaign manager makes $1,000 a month, the campaign doesn't have to report what the campaign manager spent the money on, as long as the campaign reports, we gave campaign manager $1,000 for this month for campaign managing work. It just has to be clear that these contributions are coming in support of ballot propositions, and they're being paid to defendant Eyman. People who are writing these checks have a right to know how much he's making doing this initiative work, and that purpose would be served by having a committee and having the committee pay him for his time. He could still do his work. There's no limitation on his speech. As far as Mr. Sanders talked a little bit about negotiating with vendors, he should not be able to negotiate with vendors. He clearly cannot be trusted to do that. Here, he laundered money through a vendor to get paid, and he said, well, it's their money, they can spend it what they want. It is that kind of creativity that the court needs to get out in front of if we're going to limit defendant Eyman's ability to subvert the statute. It's not to limit his speech.
Thank you. Court appreciates the arguments of the parties. This court has spent many hours reviewing the evidence presented during this trial. This court has also spent a considerable amount of time reviewing the law the court believes is applicable to this case, both statutory law and case law. What the court has not done, because it would be improper to do so, at least in my opinion, up to this point, is consider the arguments of the parties in conjunction with or in relation to the facts and the statute. So the court is going to take this matter under advisement. The court will contact the parties when it is ready to issue a ruling. The court is sensitive to the concern of the parties on the timing issue. I have learned not to place unnecessary restrictions on my time, because as a trial court judge, things come up literally on a daily basis, that unexpected issues come up on a daily basis that influence my ability to devote blocks of time to a project, all of which is to say, I hope that I can have a decision within the next 2 weeks. We're ready to announce that decision within the next 2 weeks. I can't promise it. I won't promise it, but that's my goal. And the court will make an effort to contact the parties to make certain that they are available to hear the court's decision. Thank you, everyone. Oh, before we go off the record, the deputy clerk has advised me that there might be an issue with respect to the exhibits, and I'll have a sidebar conversation with the clerk. Okay. Okay. With respect to the exhibit list, the court understands from speaking with the deputy clerk that Mr. Sanders would like an opportunity to review the proposed stipulation and order for return of exhibits and the exhibit list. And the court, of course, will allow Mr. Sanders an opportunity to do that because Mr. Sanders is appearing remotely this morning on behalf of his client. So if there is an agreement between the parties with respect to the exhibit list, that exhibit list can be signed by the parties off the record. And if there is an issue or a disagreement from Mr. Sanders, we can discuss that when we are back on the record, next time we're on the record. Thank you, everyone. Court's in recess.
All rise.
I think that stick has to.
I think it broke itself. I don't know.
Here, I'll hold this in. You want to just roll it?
Yeah, something happened. That's my expertise here.
Where was this chair, Tony?
It was right outside, yeah, right below the door outside the wall.
Thank you.
Anybody has one?
I have another comment, but I can't.
Do these go in there too?
Those go here.
Oh.
Oh, thank you guys. You didn't have to help with all that. I appreciate it. I don't know what happened. I mean, even the first one was like, oh, sorry.
Yeah, 'cause this is the same stuff we had last time.
It is, and it worked just fine. And then we tried the torts one and that one it couldn't either. So I don't know what was happening.
Sounds like come back here for April.
Yeah.
Yeah, that's what
They
it
won't
sounds
want the written going.
like. Does anybody else have iPads I need to get back
I
on?
might look at it.
Okay, because I'm happy. Okay. And I have yours. And
I'm gonna carry this guy out like a lance.
are you sure? Thank you.
Is this yours or is this?
Is
that mine?
Oh, yeah, these are mine. I think that's, I just want to make sure. You guys are best. Thank you.
You get one of these, we could jump.